Also, I think I may have posted another, I don't remember if I posted anything since Tuesday, but again, there are some other articles that I've been posting up in the course shell for those of you who are interested in just general reading about other things going on in real estate, etc. One of the things I think I posted was an article indicating that they're expecting a surge in inventory and really a surge in buyers. So a continued pickup in the market is kind of anticipated. So hopefully that'll hold true. We'll see.
How do you think it holds up in, say, the industrial market, with all of the available space like in the community?
Well, it's interesting. So when you look at industrial real estate, there's manufacturing, which there's not a lot of, and then there are different kinds of warehousing and distribution facilities. That's a hot market. There's a lot of demand. There was just a big lease signed out in the subdivision off of Eola and White Oak. I can't remember who signed it now, but it was hundreds of thousands of square feet for a long term. And so I would say that overall that market is really good and really healthy, largely because goods are mostly being produced overseas, and so they have to be brought here and held for some period of time. And so companies, particularly in a low interest rate environment, will make their purchases maybe at times of year that aren't optimal, or if they have inventory, they'll hold it for the next year if it's seasonal or something, which they can afford to do. And industrial buildings are fairly inexpensive compared to office or retail. So it's the kind of thing where the rents are fairly manageable in a greater business scheme. So yeah, I would say that industrial real estate is a very strong place to be. I've never played in that space. This is just based upon what I read and what I think I understand. But some people I've invested with in the past, I know have done some of that locally and done well with it. And industrial is a different animal in that it really matters. Location matters. It's all about transportation and access to interstates, etc. So the area along 88 fits that, and another place you'll see a lot of industrial stuff going up is on I-55 in Lamont. That's become a huge area through there, largely again because of accessibility, not just to the Chicago market, but to the interstates, to 355 and 55 and 80 and all that in that area. I suspect we'll see a whole slew of industrial development in the southwest suburbs down around the new interchange of 57 and 80 possibly, because they had never had an interchange before, and now it's partially completed. But we'll see. Takes up lots of land. These warehouses that are 500,000 and $1 million and $750,000 and $1 million square feet. They're fun to build because they're easy. You can't really leave anything out because it's just a lot of the same thing over and over again. And it's also good for our economy locally because we have two major architectural precast companies locally, ATMI over off of I want to say Prairie, but it's not Prairie, it's a little bit off of Prairie. Their plant has grown exponentially, and then Duquesne Precast, which is over really kind of in the DuPage County part of Aurora, or right on the county line. But to have two precast concrete operations like that in the same city is very unusual. Precasters usually ship their product hundreds of miles, and have two locally. That makes Aurora probably one of the precast concrete capitals of the country.
Does it keep price down by having it so readily available?
Well, I don't know how much they do. I mean, precast can be fabricated pretty quickly, and so it can be shipped to a job fairly quickly. It's much faster. Precast is and can be erected very quickly. So precast is a faster building method than, say, brick and block and that kind of thing. So long as it's been designed ahead of time, because the long lead in precast is in getting the shop drawings approved and submitted and approved by the engineers and then sent back and then fitting into the factory timeline. So if that's done ahead of time, so a savvy developer will pre-order the structural steel and the precast. So when they're at that point in the job, that stuff is showing up on site and can be erected immediately. If you've ever noticed, those buildings sort of go up like Tinker Toys, it's really very quickly. But if you go through the normal construction sequence in developing an industrial property, where at the beginning you sort of order everything, and then you get done with the foundation fairly quickly because it's just a whole lot of, it's literally hundreds or thousands of feet of 4-foot concrete frost wall, and then you just sit and wait, or not even frost wall, but just footings that the precast panels are going to go down into the ground and sit on. You just wait for a month and a half for all those drawings and things to get done and approved. So sequencing has a lot to do with getting stuff done in a hurry. The construction industry is getting better and better at building things very quickly because they're figuring out how to sort of get the air out of the unproductive time out of the schedule. So pre-ordering of structural steel and precast, which are long lead item building times, goes a long way to solve that problem. So even there, that stuff can get built pretty quickly. And they take up a lot of room. So the old part of Aurora, where's ATMI? Is it with the old Stevens Adamson plant? I think from decades ago. I think they're in that location, that area. That would all be dead industrially as well. So that industrial development is not only important to economic activity, but specifically to Aurora because those precasters have grown a lot. And that's not the end of the precast. If you anybody here work at Unilock or know anybody who works at Unilock? Unilock is the paver company over on Mitchell Road, Mitchell and Sullivan. That's not, they call them brick pavers, but they're not. That's concrete. So that's another precast concrete operation in town. So I challenge anybody to find any place where there's more precast concrete manufactured in any one place than we have here in Aurora, which is a good thing because then if building is strong anywhere, then those places are busy. Yeah, so that's a positive. Industrial market, I don't know. My colleague here, Charlie Ritchie, who started here just a little over a year ago, revitalize our manufacturing program. I'm really optimistic. He and I have talked a lot about this. I tend to think that manufacturing is on the rebound from what I read, but I'm still not seeing it. And as I think I mentioned, a couple of weeks ago, CAT has announced they're going to close their Joliet facility. He's a former CAT employee, and I think he suspects that they're not going to stay in Aurora too long. If that happens, I think that's a major blow, because CAT is like the main throwback into the 70s. They're the main plant that's been here forever. So many of the other ones, Lion Metal and Steel Case and so many others are either gone or next to nothing anymore. I don't know how many people are even employed consistently at CAT because they're there and then they're laid off and then they're there and then they're laid off, so I don't really know how big a part of our economy. Part of that's emotional, and that's an awful lot of square footage over there. I don't know how many millions of square feet they have under roof at CAT, but it's a lot. And if that plant were idle, that would just be a huge waste of, I don't know what you would redevelop it into, if anything ever. So we'll see. I know that at the Wrigley plant in Yorkville, right, they're going to shift all their Skittles production there. So that's pretty exciting. So if you don't eat Skittles now, it's very important that you start, because that's 80 brand new full-time manufacturing positions paying, $15 an hour plus, which is pretty good for these days, and so that's kind of connected to the whole Wrigley Gum thing and all that. So it's always nice when there's some new, manufacturing coming into your area. How much more of that we'll see, I don't know. There are manufacturing facilities around, but this is another challenge we have. Anybody here, is there family or know anybody who's in the manufacturing business on any level? Okay, so what I'm seeing a lot, what I'm hearing a lot, is that the next generation doesn't want to get in the business. And so you've got people who are in the business, manufacturing is oftentimes a family operation, and the next generation coming along, they don't want to work in the plant, they don't want to be in manufacturing, they'd rather be in technology. It's not that they're ne'er-do-wells, they just don't follow that path in many cases. Whether it's a job shop or an existing business, then a lot of those businesses are being sold off because that older generation is like, okay, well, I'm second, third, fourth, fifth generation, whatever, what are we going to do with this? The kids don't want it, so they sell it to somebody. Or they turn it over to somebody like Northern Trust. Northern Trust Bank in Chicago, they're really just a kind of a large private bank. Northern Trust manages a lot of business assets, and they run manufacturing facilities for families that own them but don't have anybody in the family anymore who wants to be involved. Well, when that kind of thing happens, you lose the local flavor of it, and it gets merged, and maybe they close a plant, or maybe they move production to a different location, or whatever, because it's all about the numbers. So, again, I'm optimistic, but cautiously so, that manufacturing and industrial will continue to grow. I never would have imagined 30 years ago, if you had told me how deeply we've been injured in the manufacturing segment, I never would have imagined that industrial real estate would have ever recovered. But it recovered because of the same reasons that it was failing, and that's because of the need to redistribute all the stuff we import.
It's going back, it's too expensive in China. China's pricing is
Well,
also-
yeah, right. They're having the same problem as everybody else will have. Labor gets more expensive, cost to produce, right? People want benefits. You get to the next generation, whatever, and people, I'm not working for the slave wages my parents worked for, whatever. People start getting, ambitions. It happens everywhere. And then you have quality issues, use of lead, other kinds of products. There's different quality control. China's suffering some huge environmental problems with pollution, coal fire use. So as the regulations catch up, the costs there are going to continue to go up. And then you have manufacturers like CAT who have said, we're not going to build any more in Asia. We're going to use the plants in Asia no longer to ship to the U.S. Or Canada, but we now have enough plants in Asia to serve our Asian clients. And then the plants in the U.S. are going to serve North America. So their last plant they built where in Arizona, I think. They're headquartered in Peoria with the plant here, shutting down Joliet. So they're moving production south and southeast, which is still kind of a competitive problem for us. It's a challenge for us. I mean, and this may seem off topic, but it's really not. Everything about real estate comes back to the demand. And if Illinois is a problem state in that people don't want to stay here or don't want to work here or can't find the future they want here, they're going to end up going somewhere else. And they don't have to move to China to find the job. They just have to move to Arizona or to Texas or to South Carolina. When I was in Greenville last year visiting my daughter and granddaughter, BMW announced, I think it was in August, that they were going to spend $1 billion. So just imagine if this were to come out locally here, that some manufacturers, we don't have anybody like this here anymore. Maybe Chrysler and Belvedere, maybe. But BMW just announced they were going to drop $1 billion in plant improvements, and they were going to do it in like 10 months. Holy crap. So, and they're employing hundreds, not a few dozen, not 80 people to make Skittles. They're employing hundreds and hundreds of new people at that facility, in addition to the hundreds of people they already have. And manufacturing pays well. So Greenville, South Carolina is one of the fastest growing areas in the country, in part because it's home to North American headquarters for European companies like Michelin Tire, but also because BMW has the plant there in Spartanburg. And so this is a challenge. It'll be interesting to see whether our current governor makes enough changes to have it make a difference. I'm skeptical. Some of what the governor wants to do affect me very much personally, both as a state, retiree, a pensioner, and also an owner of real estate with the state and a school district that's state funded for tenants. But at some point in time, people need to want to come here, or at least to stay here. And this area out here right now, I mean, we really need stuff to happen. So, yeah, it's all kind of interconnected. What's good for one, hopefully, is good for the other. We'll see. So far, nobody's building apartments in Aurora that I know of, and that'll be a sign. When people can see that there's that kind of need for people because of job creation, then that'll be a real good sign we're in a positive position. You're seeing quite a bit of it in the city, but most of that is luxury stuff. And small, really tiny. So we'll see. All right, let's get back to this. So the last few slides here, it's going to kind of wrap up the rest of it. I'll try and spell out the details. Again, a reminder, there's a quiz up here. Grab that before you go tonight. It's a self-test. The contract forms that we use, we saw this somewhat in Chapter 6. You can see it again here. Where do they come from?
Realtor?
Yeah, mostly it's your local realtor association. The local board of realtors will have what's known as a broker-lawyer committee. Mostly some of the managing brokers from the area offices, those that have good experience working with contracts and who have a sense of what's going on currently in terms of trends of financing, buyers, sellers, and an attorney or two who volunteer to serve on this in hope in return for networking and picking up future legal business. So those pre-printed contract forms then have been vetted by lawyers, and they're then looked at by a number of different associations. We have about 11 or 12 realtor associations in the greater Chicago area, including DeKalb, all the way into the city, all the way up to the state line, but not including Rockford, but yes, including Belvedere, and down south into Will and Grundy County at least, if not beyond that. So there's quite a few different associations that are all agreeing to using the same basic forms. That's a place where a lot of the standard agreements come from. Also, your firm may have them. So wherever you go, find out right away, what form do I use? If you got a listing appointment a week after you start, you should know, does the brokerage have a listing agreement, or are you just going to use the standard association agreement? Find that out, when you get there. You'll probably, for purposes of this chapter, sales contracts, probably going to use the standard multi-board contract. Or your case might be different. I don't know what they would use if you're on the Rockford side of the transaction up there. Different MLS, different local association. They may or may not use that same multi-board agreement. I don't know. But if you were doing a deal in, Boone County somewhere, you're probably going to use that same standard board agreement that's in the text, or a newer version of it. So, as the agent, for the parties, using these pre-printed contract forms to fill in blanks, it's important to know, this is a common state exam test question, and it's very important to know in practice. You cannot leave any blanks intended to be filled in later and have your client sign an agreement, whether it's your listing agreement, a buyer agency agreement, or sales agreement, or a lease. You cannot, under the license law, allow a consumer of any kind to sign an agreement where you're supposed to write something in later. The challenge here is, going back to that contract negotiation we talked about earlier, where it's done on Sunday night at 6 o'clock. 6 o'clock, the offer's made, the counter offer's made at 8, then pretty soon we're doing things back and forth, 8:30, 9, 9:30, 10 o'clock at night, and something hasn't been answered. And the temptation is, well, just leave it blank and we'll fill it in later. You can't do that if the parties have signed that agreement. Violation of the license law. It's all about consumer protection. So just something to keep that in mind. And you have to have your client's permission to be able to alter or change anything. So if there's a critical item that's in for negotiation, or that maybe needs to be taken care of right away, but you can't reach your client, you can't change it. Doesn't matter whether, again, it's a sales agreement or your brokerage agreement. So when you're working with your clients under, say, a listing agreement, and you have an oral agreement that says that, okay, we're going to list the house for $200,000, even though I've told you it's only going to sell for $170,000. So we'll list it for $200,000, but in 30 days, you're going to drop that price to $179,900. You agree, Mr. and Mrs. Seller? Yes, they agree. Then 30 days goes by, and you go to reach them, and they're at a resort in Central America. And you can't reach them, and can't reach them, and can't reach them. And, you're feeling this pressure, I got to reduce the price. They said they would reduce the price. You got to be able to think on your feet and go, can I reduce it? And the answer is, no matter how many times they told you orally they want it done, you can't, because all you have is the written direction. Right? If they've never given you written direction to reduce it, you can't get in trouble, except that they'll just yell at you and call you nasty names. But if you make the change without their permission in writing, now you're in breach of your agency duties to them if they say to you, hey, we didn't want to do that, no matter how many times they said they did. So again, you can't make any changes of any kind without your principal's approval. So if you're looking at something like a listing extension, a buyer agency agreement extension, changes to an agreement that you're party to, or to some agreement you're not party to, like a sales contract, get it in writing, if you at all can. Now, when you're negotiating a contract and they haven't signed it, or it hasn't been initialed finally, don't worry about that, because they still have to go back and initial it or dot it. But if it's an existing agreement that's already there, and you're supposed to do something in relationship to that, do it by email at a minimum, so that you've got some kind of paper trail that gave you direction to go forward and do that. I really, 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 really prefer to communicate with my clients by email as opposed to orally. A, there's a reminder there for me on my screen to see so I don't forget it, and B, there's a paper trail, or I can send it back to them to say, remember when you sent me this? Oh, yeah, now I remember.
So if they sent you an email saying that you could drop the price in 30 days, then can you do that?
Yeah, I would do that, because we talked about the enforceability, right? So you don't have a bilateral thing there, but they're the ones against whom you would enforce that claim that they gave you direction, and the writing is sort of in their hand, if you will. Right? So that's where the parole evidence rule is going to work out okay for you, because even though you don't have a signed satisfaction in a court, as we would say, or a signed addendum that says reduce the price, or both you and the broker, or both they and the broker have signed it, they're the ones that have given the direction, and you can follow that individual direction, and you're okay. Just make sure it's from them, not from their kid who's mad at them and wants to get even with them or something, hacking into their email account. All right, this is an important case from the 60s. It's an Illinois-specific case. We've had follow-ons to this. Again, common for test question purposes, critical to know for practice. It makes Illinois different than a lot of states when it comes to how real estate, particularly residential real estate, is handled. So back in the 60s, Chicago Bar Association sued this brokerage firm called Quinlan and Tyson, which was a big firm at the time, and said, your agents are engaging in the unauthorized practice of law. You're giving legal advice, You're drafting amendments, addenda, changes, you're doing things that are the purview of a lawyer, and the Illinois Supreme Court agreed. So the upshot of the case is, and it's been this way in Illinois ever since now, approaching 50 years, that what we can do as real estate licensees is to fill in the blanks of the pre-printed contract forms that are customarily used in our area. So that's what we do. So when the broker-lawyer committee hammers out multi-board contract 6.0 and throws it out to the agent community and says, this is what we're doing, that's the lawyer-approved contract that we can then use, and all we need to do is fill in the blanks. We do not explain the legal significance. We do not try and give people a legal explanation of the legal terms. We simply sort of follow the blueprint, follow the instructions, and that relieves us of any obligation. And it also makes it very clear that we're not engaged in the practice of law. A couple of other cases recently, I think it was also the Chicago Bar Association, either Chicago Bar or Illinois Bar, a few years ago sued Koenig and Stray, which is a big brokerage firm, now part of GMAC, I think, maybe even some other bigger entity. Koenig and Stray, a big brokerage firm, particularly near West and North Shore, and they sued them saying, you're doing title insurance work. Koenig and Stray would charge their clients a little bit of money to do some of the preparatory work for title insurance stuff, and the Bar Association sued and again won and said, you can't do that, that's legal work. Title work is for lawyers. True. Then the association, one of the legal associations sued lenders. This was more recently, just a few years ago, and said, you're preparing all these loan documents. You're making all these changes, modifications, closing statements. You're doing all this stuff. You can't do that. That's the purview of attorneys. And they lost. Because the lenders successfully defended and said, these are our loan documents. So it's important to understand where the line gets drawn here. You always have the right under the law to practice law for your own self. It's called the pro se exemption or exception. Pro se meaning kind of or by yourself. So when you look back at those brokerage agreements that you're entering into on behalf of your broker, you can modify those, you can carve them up, you can change them in any way you want between you and the party, the seller or the buyer that you're negotiating with, because as a broker, you are party to that deal. So you're practicing law for your own self. All right? So if you're sitting there with mom the night you're listing her house for sale, and she doesn't like some provision, can you strike that and change it and modify it and initial it right there? The answer is yes. Your broker will still have to approve it, but yes, you can do that. Here, however, when we're talking about sales agreements, we are not, as brokers, party to those deals. We cannot make modifications or changes because that's the chair the lawyer sits in. So that's where we have to draw the line. We do not draft amendments, which means changes. We do not create or draft addenda, meaning additions to the contracts. That's for attorneys to do. There are some standard riders that go along with the standard contract forms. If that's the case you have, like a short sale rider or addenda, for example, then you just grab the standard form and attach it to your contract. It's really an important thing for us to have on call or at our disposal as brokers a reliable residential real estate attorney or two that will allow you to call them on their cell phone Sunday night at 8 o'clock. When you say to them, my buyers want to add this provision into the contract, and I'm wondering if you could help me word it. Or, what do we do about this? Because, I can't draft anything. My buyers refuse to write anything down themselves, but I don't want it to get missed when the attorney review is done. Also, another way around things, if you run across some kind of an issue because of the business that you do that comes up frequently, if an attorney will draft for you a paragraph ahead of time that you can pull out of your briefcase and use, you're good, because you didn't write it. And just keep that in mind. This is one of the things that Illinois state law is very concerned about. In general, they want you to avoid the practice of law, and they want you to understand when do you call in experts. And so when it comes down to legal issues, you need to know when it's time to pick up the phone or go to the email and contact an attorney. Very common for residential brokers to recommend legal counsel to their clients. That you can do. Have 2 or 3 lawyers, business cards handy, or phone numbers, names, whatever, and hand that stuff off to your clients. All right, so I mentioned here, again, the broker's party to the contract, they can make modifications. When you get into leases or certain other kinds of contract types, you may not have any pre-printed forms. So you can use a pre-printed form for a lease. If you're gonna do leasing, for example, of residential, you can go to Office Depot, Office Max, Nolo, LegalZoom, you can get pre-printed forms there, and they might work. Those meet the letter of the law as well. Keeping in mind that all the blanks have to be filled in or crossed through if they don't apply. You can't leave them blank if your client's gonna sign it. But most commercial sales agreements, more complex deals, and most leases, those are drafted by attorneys. So you probably won't even have a standard agreement to work from. Find the standard contracts as you get into the business and get a better sense of what they look like and start to learn them as soon as you can. Illinois law requires that a real estate sales contract state in bold-face print or type, uppercase font might suffice, that it is a real estate sales contract. Why is that so important? Why can't think about the kind of the stupidity or the nonsense of this. You go to the printer, you have a bunch of contract forms drawn up that say real estate sales contract, got a bunch of blanks in them, and they're sitting on the shelf in your office, and those blanks are there, nobody signed anything, yet the paper says it's a real estate sales contract, is it?
No.
No, because it's the piece of paper with a bunch of printing on it, yet it says it's a real estate sales contract. So why do we do that? Because what's the first thing that's going to happen with this contract? The first use of it isn't as a contract, the first use of it is by which party, buyer or seller? The buyer, right? They make the offer. So when the buyer, with your help, fills it out, and you'll probably fill it out on their behalf at their direction as you're sitting with them, and then the buyer signs it, the seller's half of the thing is blank, right? I mean, so all it is an offer to purchase. So why doesn't it say on the thing, offer to purchase?
Because it becomes a contract once it's signed by the other party.
Exactly. So it's important for us to remember our job to protect the consumer. And not all consumers understand when an offer to purchase ripens into a contract. So if it said offer to purchase on the top, and it magically became a contract, and your buyer or seller doesn't understand they're now bound contractually, that's a problem. And that's why these things have to say real estate sales contract on them. Better that you have blanks or offers to purchase that aren't yet contracts that say contract, than you have contracts that papers that are legally contracts, but the people signing them don't understand that's what they are. Right? So that's critical. You've been in the business long enough to remember when that changed. And I was teaching a class at a real estate office at the time before I was teaching here full time. And in their cabinet, shortly after this law had changed, they had a bunch of forms that still said offer to purchase, and that's what they were using. So this is what you should see. Now, multi-board 5.0 contract is in your book. We're not going to go over that at length in this class. We will in Real Estate 105. We'll spend an hour or so kind of walking through that. And you'll spend more time once you get licensed going through that and getting trained on how to use it, because you need to know how to walk your clients through that. You're going to sit with a buyer and explain to them every single paragraph and what they need to answer in terms of those questions: offer price, finance contingency, etc. What I want to point out is that there is a new contract out. It's multi-board 6.0. And that's what I will give you, and that's what we will go over in Real Estate 105. I'll give you a PDF. I'll post it online, and you can print it if you like. There are some differences, but they're not huge. Every few years, this contract goes through another iteration. Things change a little bit, needs to be updated, modernized, change the process a little bit, whatever it might be. And when we say multi-board, what we're saying is whether you write an offer in Winnetka, or in Joliet, or in Morris, or in DeKalb, or in McHenry County, you're going to use the same contract form. And the advantage of that is you get used to it easier. Although you might want to check if you know anybody up there, to get a sense of what they're using. It used to be, when I got into the business, it would be a different contract in Joliet than in Aurora. And when I would take an investor to Joliet and we would write an offer on the only contract I knew, the pre-printed contract form commonly used in my area, would fill it in, I would get pushback sometimes from the listing broker in Joliet who would say, I don't know what to do with this. I don't know if I'm allowed to explain this to my client because this is not the contract customarily used in my area. So now we have this wide geographic area where we're all using the same contract form. The only thing you'll see, I believe, is that some offices will be faster to switch. So when you get into business, you may find some offices using the brand new 6.0 contract and some still sticking with 5.0 because their agents have not yet been trained on the newer version. So just be prepared to look out for that. There may be, I can't remember off the top of my head right now, there may be some significant enough differences between the two that you would need to point those differences out to your client in one case or another. But again, we'll just, all we're going to do is walk through the 6.0 contract when we get there. Talked briefly before about earnest money, so let's talk about what this really is. You have to have earnest money on a contract, and before I can answer this, think about the fact that there has to be consideration, right? There has to be consideration for a contract to be valid. So do you have to have earnest money on a real estate sales contract?
I'm gonna guess no.
Yeah, the answer is no, because earnest money is not consideration. It's a deposit. It's down payment money. It's represents the opportunity of the seller to seize something of the buyer in the case that the buyer defaults under the terms of the contract. So it's actually really an escrow deposit. And the term escrow, if I haven't mentioned this already, means to hold something for someone else. So in an earnest money transaction, an earnest money deposit, the escrowee, the person receiving the escrow deposit, the escrower is the person who writes the escrow check, the earnest money check. The escrowee is the brokerage firm or the title company or the lawyer who holds the money in their escrow account. So if you're encouraging your buyer to write an earnest money check, know who the escrow agent is going to be, and if it's the other broker, if it's XYZ Realty, the check will probably be made out XYZ Realty as escrowee. So they don't accidentally deposit it in their operating account. They'll know this goes in our escrow account. So the earnest money deposit then becomes a show of good faith by the buyer that they're going to follow through and fulfill their promises under the contract. Can the seller put up the property, the buyer puts up some cash. Sponsoring brokers do not have to have an escrow account. I do not have one. Along with dual agency, this is the next big area in consumer complaint. They didn't handle my earnest money properly, so I won't hold it. Never had a negative impact on me. You can have interest-bearing accounts. It's in the contract. If you go to the contract in the textbook, you'll notice under the optional provisions that are there, one of the optional provisions is to have an interest-bearing escrow account. All deposits, all earnest money deposits are non-interest-bearing unless the contract specifies otherwise. Illinois law does not allow an escrow agent, meaning in this case probably a broker, to earn any money on that interest. So it has to be deposited into a non-interest-bearing account unless the parties give a letter of direction, in the contract in other words, to the contrary. In which case the earnest money belongs to the buyer, it's their money, we can credit it to the buyer at closing, and any interest paid on that money will be credited to the buyer, and the bank will send them a 1099 INT for the interest if it's significant enough. And the buyer will fill out a W-9 form. That W-9 simply is their name, their address, their taxpayer ID number, which for us is usually going to be a social security number when you're dealing with individuals, so that information goes to the bank along with that escrow deposit when the time is right. Now the escrow money does not get deposited until after the contract is formulated. So the buyer can write an earnest money check. I usually procedurally have the buyer write the earnest money check, I photocopy it, I print copy across their signature, otherwise it could be considered a valid tender. And then I submit that along with the offer to the seller so they can see my buyer is serious enough that the earnest money check has already been written. That the money is there, in effect. But I hold on to it as the buyer's agent until there's a contract. Then I hand that money over to wherever it's supposed to go to be deposited by the end of the next business day after the contract has been formulated. So again, if you have an interest situation, then that needs to be specified, needs to be clarified, and a new account or sub-account or something needs to be opened, and that interest is paid to, and the account belongs to the buyer. Commingling, this is we talked about earlier. Commingling is a no-no. It's the mixing of your operational funds as a broker with that of your clients. That is illegal in Illinois. with the exception that you are allowed to put enough money in an escrow account to maintain a minimum balance or to cover the monthly fees you get hit by the bank. Conversion is just another word for theft, so that's worse than commingling. At least in the case of commingling, it was accidental or you intended to put the money back. Conversion, you were just stealing. So it's very common. People will say, well, what's the standard amount of earnest money? What should I recommend? We talked about this, I think, a little bit in chapter 4. So earnest money is always negotiable between the parties. The parties, in this case, the buyer and the seller. It's up to them. You can make recommendations to your buyer as to how much earnest money they should put up, but for test question purposes, due to antitrust concerns, there is never a standard amount of earnest money. Just like there is never a standard or typical commission, even though there is. Right, so same kind of thing is true here. You know, agents might say, oh, I always get at least $500, or I always use 1% or something. That's fine. And talk to your broker, see what they recommend, what is normal or typical or customary, or puts your buyer in the best light. But also look at your buyer. People who are putting little to no money down, and yes, you can still do some no money downs, particularly if it's a VA loan. If they're not putting any money down, they might not have anything for deposit. So don't expect your client to put up 2% if they're a VA buyer with no money down and they don't have it. Try and get that deal together without it. And you don't have to have earnest money at all to make the contract legal. So in the event that the buyer defaults, they're in breach of contract for some reason. They didn't apply for financing soon enough. They have failed to ratify some other term or whatever they needed to do, whatever it might be. That earnest money can serve as liquidated damages. Now, liquidated damages are different than consequential damages, where you sue somebody because they damaged you and you have to prove them and then they make you whole again. Liquidated damages are something agreed to contractually between the parties that don't have to be proven at all. So if your buyer puts up $3,000 in earnest money and then defaults under the contract, they just refuse to close, or they don't like the financing terms they were offered even though they're within the constraint of the contract, whatever the case might be, as long as they're in default, that money theoretically should default to the seller. If they want to collect that money, it should go to them. And then that serves as liquidated damages, and that's the end of it. Parties go their separate ways, and the seller can sell the house. Some listing agreements, handle this how you like and talk to your broker about what the company policy is. Some listing agreements will state that defaulted earnest money goes first to pay the broker who didn't get a commission on the deal, and then if there's anything left, it goes to the seller.
Seems fair and reasonable.
It always seems fair and reasonable when you're the broker trying to get paid for your efforts.
Right.
I think you enforce that provision if it's your seller who is as much at fault or something, but I don't know. Anyway, that's entirely up to you guys how you would handle that in practice. Just know that that's a possibility. I don't think I've ever toiled under that. I've certainly never enforced it if it was there, but I've seen that provision in agreements over the years. Even if your buyer is not at fault, their money is always at risk. So let's talk about how earnest money works mechanically. Once it's put up, the contract serves as direction that it's going to be held by somebody. And the contract form, as you'll see it in the text, states who is it. The listing agent, the buyer's agent, and the new multi-board 6.0 contract gives you the option of somebody else, an attorney, title company, whatever. So the contract form then tells you, here's what you do with the earnest money once it's formulated. Now let's say the buyer's not at fault, but the seller refuses to release the money later when the buyer can't get financing. The buyer applies, the buyer does everything it's supposed to do, they do it all in a timely way, and the banks just say, no, we're not lending this month, which was happening in 2008. If the seller refuses to turn over the money, you got no earnest money refund coming back to the buyer. The agents for the parties, as far as escrow money goes, are their attorneys. So direction to return earnest money or forfeit it must come from the principals or their agents. And their agents in this case, let me be clear, are not their brokers. So if the seller's attorney says, go ahead and release the earnest money back to the buyer, you're good. If the seller says, go ahead and release the earnest money back to the buyer, you're good. But absent direction from one of those in writing, that earnest money stays where it is. There are all kinds of possibilities we can get into, but more for a managing broker course that we talk about, all the things that can happen with earnest money, but understand that you need written direction from all parties to release it. So even if the buyer is not at fault, all it takes is an uncooperative seller, and they may not get their earnest money back right away. They might be entitled to it and get it back later, but if that's all the money they have, and they gotta write another earnest money check on the next place they're gonna try and buy, that's a big problem for them. About 5 years ago, a major commercial broker here was upset because their seller was not willing to release $40,000 that they knew absolutely needed to be released back to the buyer, and so they went ahead and released it to the buyer. Their seller sued them, and that broker lost $40,000 plus legal costs. Questions at all about earnest money or escrow deposit, whichever you want to call it? All right. We've already introduced this concept a little bit, and we're going to come back to it again. I think maybe in the next chapter, and again probably in finance, but let me kind of lay this out for you pretty clearly. We can split title into multiple parts. Specifically here, we're talking about a concept known as equitable conversion, where it allows us to engage in a little bit of legal fancy footwork and say that there's two components to the title. There's the legal title, in other words, whose name is on title. And then there's equitable title, who has the rights to do whatever they want to do with the property. And those two things are different. So we introduced this concept without calling it as such when we talked about trusts in Chapter 8. Because we talked about the party that owned the beneficial interest, and then we talked about a trustee. Bless you. So the trustee could have legal title. Their name is on title, Old Second National Bank Trust 1234. But they have no use to the property. They can't just sort of move into your kitchen and have lunch with you because they are on title to the house. The equitable interest remains with the true property owner, who was the trustor or the owner of the beneficial interest under that land trust arrangement. So equitable title happens, this split between legal and equitable title happens all the time with sales agreements. So when the seller agrees to sell and the buyer agrees to buy, once that contract is signed, think about this for a minute. Once that contract agreement is signed and both parties have made their full range of promises contained within this sales agreement, at that moment in time, who owns the house? I mean, all the seller has done is agreed to convey. They haven't collected any money other than an earnest money deposit, which isn't even in their hands. It's in the hands of their broker, their lawyer, or title company. And title has not changed in terms of there's been no deed prepared or anything. There's still a lot of contingencies in the contract. So who still owns the property once that contract is signed? All right, so the seller still owns the property. So a day after the sale, the seller, feeling guilty that their garage is a mess, clears out all their stuff and installs $3,000 worth of shelving along the walls and hooks in the ceiling, all so they can give that to the buyer and make that garage more organized. Can they do that?
Not a day after the sale.
Why not, if they own the property? See, you're instinctively recognizing that the seller has given up some rights, right? The buyer purchases the house in the condition that it's in at the moment you sign the contract. And once that contract is formulated, the buyer receives what we call equitable title. It's really now the buyer's house, though the seller retains legal title. What the seller really owns at that moment in time is the obligation to keep the house in that condition until the time of the closing and to collect the sales proceeds. Other than that, title has transferred to the buyer. Make sense? So I'll give you an example of where this kind of thing was a really important thing for me. Walk into the house for sale in West Aurora many years ago, under contract within a week of the closing, and on Sunday, I get a call from my seller. Heavy windstorm the night before blew over about an 80-foot tall oak tree in the backyard, snapped it off about 2 to 3 feet above the ground. And I'm thinking, oh my God, what kind of damage is there to the house, to the garage, whatever. So I go there, and this tree is laying sort of in the branches of another tree, maybe lightly brushed the roof, missed the garage, and it's laying across the power line between the garage and the house. No apparent damage physically to anything, except that the tree is clearly snapped off 3 feet above the ground. You know, this was a thing. This had an 18-inch diameter. I mean, it was a large tree. In the whole backyard, like a lot of those West Aurora homes, filled with very large old trees. So what pops into my head with this idea? Who owns that house? Not my seller, the buyers, right? So we get on the phone, call the buyer's agent right away, tell her what's happened. She says, I can't come over, but I'll call my buyers. She calls her buyers. They must have been staying nearby. They were relocating. They were there in 15 minutes. So they look at it. We all agree, cleaning up the mess, seller's problem. Paying the cost to get it cleaned up, seller's problem, their insurance company, whatever. But now you see the buyers have seen it. They know what it is. They've blessed it, and we moved on. If they had otherwise done a final walkthrough, not known about this tree being gone, because the seller is just figuring, oh, this is my problem as a seller, I'll take care of it, I'll fix it all up. And they come out and this tree is gone. Hey, where's my tree? I bought that house because of that tree. The way it shaded the deck, I love, roasting acorns, in the fall, whatever. We would have had a problem because the seller would have failed to deliver the property in the same condition it was in at the time of the contract. That's this idea of an equitable title. Now, Illinois also has this Uniform Vendor and Purchaser Risk Act. There's a standard, Uniform Act. Illinois has modified that a little bit. But who has to insure the property is different from state to state. See, the common law situation was that the property was typically going to be insurable by the buyer right away. Because if you go back 5 centuries ago in England, what were people buying but land and maybe a hut? All the value was in the land. So because of this concept of you agreed to buy it, you're the equitable interest owner, you should insure it, there wasn't much to insure. But today, so much of the value is in the improvements, aka the house or whatever, that we obligate the seller to continue to insure the property in many cases, but not in all states. But in Illinois, the seller is obligated to maintain insurance. Important again to understand, if you go to another state, check this out. Before you buy a piece of property somewhere, make sure you understand, do I need homeowners insurance at the time of closing, or do I need it right when we're signing a contract so I know that it's insured? Because if you're agreeing to buy it and you don't insure it and it burns down and that was your loss, you got a problem. Again, in Illinois, it's the seller's problem, so it works mechanically. It makes the most sense, even though that's contrary to common law, because again, in common law evolution, we didn't have so much money tied up in the improvements. All right, so again, hopefully you can follow that premise or that idea. Yes.
Sorry.
That's right.
So then, if that was the case with the tree, can the buyer withdraw from the contract?
I don't think so in that case, because again, it was their property. Really, at that point in time, it was an act of God. It wasn't neglect or a willful problem by the seller. So all they could really do was look at it, same as if they were the owner otherwise, and go, we lost the tree. But because of the nature of whose obligation it was to clean it up, right, they were just able to say, okay, fine, we know what we're getting. And they walk away, they go back to their hotel for 4 days. In the meantime, the seller calls their insurance company, they call a tree guy, and they clean it all up. And had there been any other damage, electrical, roof, whatever, to the deck, that also would have been the seller's problem. Fortunately, none of those things existed. So see where it's a little bit complicated. You got to kind of follow the bouncing ball. Unusual circumstance, but like a lot of my career, it turns out to be great classroom examples. After that, I don't know what I was doing for all those years, but it's something to kind of pay attention to. Liquidated damages, I think we already addressed that. As far as the earnest money goes, again, that's just kind of in an odd place in the text. Within the sales contract, there are a number of contingencies. And again, you should read, even though we're not going through it right now, line by line, you should read that standard contract in the text and try and find these things. Pull out the PowerPoint slide, pull out your notes, and see what you can find here. So one of them is an attorney review provision. And again, we'll look at this in some detail in Real Estate 105. But I just want to point out that attorney review is not an all absolute save kind of provision. It's a little more complicated than it might sound, but the basic idea, the basic premise is that the attorneys for the parties have up to 5 business days to review and approve the contract and make modifications. Which could lead to the contract falling apart, or could lead it to being ratified and eventually executed. But it's not a catch-all. So it may be that you don't want to lean too heavily on that attorney review privilege. Again, we'll review that more in the follow-on class when we have more time to just sit there and stare at the contract for an hour or so. This is yet another reason why you should recommend to your buyer that they should have an attorney. See, it's almost impossible for a seller in Illinois not to have an attorney. You can't prepare their deed, transfers the title. You can't provide any title work. So by the time the seller pays for money to have the deed prepared and have the title work done, it's only a couple $100 more that the average residential law firm will charge them to also review the contract, answer any questions, handle inspection issues, and whatever other things might come up. And you don't pay anything until the closing. Usually, that's the norm for a residential real estate attorney. They make their money based on volume and handing off some of their work to a paralegal or other clerical assistant that can help them do that volume. So again, a buyer, you need to tell them why they should have an attorney, because they'll say, why would I pay $400 or $350 for an attorney when I don't really have to have one? You want somebody to review your financing documents? I can't do it for you because that would constitute the practice of law. I can look and see if it's the right interest rate, but after that, I can't really help you. An attorney can do that. An attorney can pick up the phone, call the lender and say, hey, this isn't the deal that you promised my buyer.
Is it typical for a sponsoring broker to have like an in-house attorney that they would refer all that kind of stuff to?
In-house? No.
Well, not necessarily in-house, but
somebody that
they
would refer
work
to.
with, right.
Usually that will come down to you as the individual broker who you refer people to. I have seen cases as cozy as the spouse of the broker being the attorney they refer everybody to. Top producing agent in the office that I was in, she's up north somewhere, Algonquin or wherever. Her husband was a real estate attorney and she just referred every client. She said, you can do business with who you want, but I'm referring you to my husband. He did a lot of business that way because she was doing, in those days, $20 million a year. I don't know if she's still in the business today, but she did a lot of business. She and her team. So you can do that. I usually had 2 or 3 attorneys that I would refer people to. Even today, when I'm involved in deals, I don't necessarily use the same attorney on every transaction. Like any other good liability avoidance, if you refer them to 2 or 3 attorneys and they select one and it turns out to be a bad arrangement, it's not your fault. If you always refer them to the same person, you might get sucked into that legislation. By the way, and I bring this up not to make things more confusing, but it's an awkward situation. If you're working with your client and you think their attorney is a problem, they're either incompetent, they're not responding in a timely way, or you think they're actually committing fraud, which I've seen in one case at a closing. So I've asked a number of attorneys, do I have the right as a broker to tell my client they should fire their attorney and hire another one? And I've been told every time, yes, you do. Never once has an attorney pushed back and said, no, that would be the practice of law. So if you think there's a problem, you should address that with your client. Most real estate attorneys are very good, and they're very personable. If you have a thing against attorneys, get over it. These are not trial litigators. These are not criminal prosecutors or defendants, defending attorneys. These are people who are in residential real estate because they like the practice. They don't want to do divorces. They don't want to do criminal law. They want a result where everybody's happy. Seller gets cash, buyer gets the property, and that's what they do. And they work for less money, to have less stress, and keep that stress-free for everybody. So, learn to make some relationships with attorneys, lean on them, and you'll find that they are very helpful. If you refer business to them, they cannot pay you for that. We'll talk about this later in the course. They cannot pay you referral fees. But if you do refer business to them, you will find that most of them will go out of their way to help you. They understand that they're in an advantageous position in Illinois because of Quinlan and Tyson case, and they will not leave you hanging because of it. Finance contingency. I'll buy your house contingent upon my ability to get finance. See, this contingency is this idea that I'm going to do this, but only if everything falls into place. Only if my attorney says the contract is okay. Only if I can get the financing. Only if my inspection turns out okay.
Only if I win the lottery.
Yeah, but that's what you make it contingent upon. So contingent upon finance, or what we oftentimes call the mortgage contingency, is one of the first ones in the contract, should be on the front page. This is very common. You don't have to have this, but you probably want to have it as a buyer, because if you apply for financing and you can't get it, you don't want to be subject to the loss of your earnest money. So what happens in this finance contingency is you specify not only that you're going for financing, but exactly what kind of financing you're going for. The interest rate, the term, fixed or adjustable, all these basic things, because it's a notice to the seller that says, if I can't get this or better, I ain't closing. And then the seller has to look at that in consultation with the listing broker to make sure that that's reasonable. So if the finance contingency today says, I'm going to get a fixed 30-year rate for 3%, and that's what this offer is contingent upon, the listing broker should say to their client right away, don't accept this, because that rate doesn't exist in the market. Now, if it's a fixed rate of 3% for a 15-year loan, that might be a reasonable bet. So again, you'll need to know both as a buyer's agent what you're financing your client is going for, and as a listing agent, what's commonplace in the market, what's likely. Because if it's not likely and they can't get it, that's a way for the buyer to just say, well, we said it was contingent upon this financing, we couldn't get it, so we're out. The inspection, you pretty much do inspection for everything. Home inspection is the most common thing here, contingent upon getting a clean home inspection. Or if it doesn't get clean, if it's not clean, we negotiate maybe some kind of amicable resolution. Read that provision, look at the days, the times, and things. Again, we'll look at it in more detail in Real Estate 105. But it's a very common contingency. Buyer has no obligation to do inspections. You should, as a real estate agent, as a buyer's agent, recommend that they do them. You don't want to recommend, they're a waste of your money. They don't do it, there's a problem, and now that only would have been caught through an inspection. And that could happen. So recommend to them, even if you have to say, I know you don't have much money, but you might want to seriously consider spending $350 or $400 for this inspection. If nothing else, you can come to the inspection and the inspector will walk you through your new house, tell you how to maintain the furnace, tell you what to look out for. Even if we don't discover any problems, you'll get a wealth of information about how to operate this place. And inspections are an interesting kind of thing. It can help to remove problems that otherwise would turn into litigation, if for no other reason than to manage expectations. So if you went to a used car dealer and spent $10,000 and bought a car with basically no warranty on it, and you got in that car and you drove it down the street and you realized it pulled severely to the left, you might be really annoyed and feel like you just got cheated. But if you bought a $30,000 brand new car 5 years ago that today is worth $10,000 and you're a little short on change and you don't take it into Firestone to have the front end aligned or the tires done or whatever, and it pulls severely to the left, you don't mind because you've learned how to drive that tugging the wheel back the other way, right? You're accustomed to it, so it's okay. When somebody buys a new house, they're kind of expecting it to be problem-free, even though that's not promised in the contract necessarily. So if that house is the equivalent of that car that's going to pull to the left, wouldn't it be nice if your buyer knew it and bought it anyway? Okay, this is something we're going to have to deal with, and an inspection helps to point that out. The real contingency in this contract form, and again we'll go over it in more detail in the next course, are these property to close or property to sell contingencies. I'll buy your house contingent upon the sale of my house. That means that if my house doesn't sell, I ain't buying your house no matter what else happens in the universe. Who knows what that means? Maybe the buyer's from Cincinnati. Maybe their house isn't even on the market. Maybe nothing in that neighborhood has sold in 20 years. Who knows what kind of condition it's in? And now they're making an offer contingent upon that thing selling. Do you want to take an offer like that as a seller or not take an offer like that? Sometimes as an agent, you're put in the position to recommend to your seller, I know you've got an offer and I know you like the price, but the odds of that other house selling in a timely manner so that you can then turn around and buy what you want to buy in the future are maybe not that great. I think you should let this offer go. That's the kind of thing you can have to wrestle with or struggle with where there's not a clear answer. Because there's only one reality. So in the end, you'll know what happened, but you won't know what might have happened. And so you just have to look at it. Again, read that provision. It's the first optional provisions in the contract, in the text. Maybe it's not contingent upon the sale of their property, but contingent upon it closing. In other words, it's already under contract, but they can't close on this house unless that one closes. What's the risk of that? It would be fairly high still, not as high as it's not even selling. Again, something you need to look at and sort of measure and decide whether you think your client should get into that or not. You can have a property sold contingent upon a property sale and continue to show it to the market. Because anybody who comes along to buy it who doesn't have a house to sell or house to close could make an offer, and so long as the seller in the original contract put this kick-out clause in that says, all right, if we get another offer and we go to contract with that new buyer, we're going to give you 24, 48, 72 hours, something like that, to waive your contingency on your home sale or home close. Otherwise, we're going with them. So it is possible to kick out the original contingent buyers and replace them with non-contingent buyers, but it's a little cumbersome. And again, for reasons I'll explain, now we've got a couple minutes now. For reason I'll show you now. It's a little bit problematic. So what I'm putting up here on the board are some data fields that are in the MLS. I'll probably do this again in Real Estate 105, but we've got a few minutes here. So when you put something in the MLS, you'll put it in, for example, and it'll be listed under a status. It'll say new when it's brand new, active after it's been in there 8 days. If you change the price, it'll say price change, whatever. One of the possible data fields in the MLS for the status of a property in there is contingent, CTG. This is just our local MLS. This is not anything for the test or for the course. But if you put something in as contingent, then another data field pops up and you have to tell it, and there's only one field here, contingent on what? You could put in FIN for finance. You can select attorney inspection. Those are two options. Sometimes there's both of them. You can only pick one. But there's also the possibility of something like a home sale with a 24-hour kickout, or a home sale with a 48-hour kickout, or a home sale with a 72-hour kickout, or a home close, etc., all the way down. These are all just sort of fields you pick out of a box, a drop-down box. Now, homes that are sold contingent upon financing or attorney and inspection review typically close. 9 out of 10 or higher was typically close. So if you're a very busy buyer's agent with very busy prospective buyers, and there's enough inventory in the market, I submit you probably will not show them homes that are contingent, because the odds are it's gone. And why would you do that to yourself and to your clients? If they find the place and they really like it and it's under contract and it closes, now you've just kind of pulled their chain emotionally. That just doesn't make any sense. So the problem is those 10% of these that don't close and the ones that are home sale or home close contingencies now aren't even going to be seen by buyer's agents. You could say it's available for show, but if the agents don't find it when they do their data search, then there's a problem mechanically with taking a contingent sale, putting it in the MLS as such, because now the buyer's agents aren't even going to search that. They're only looking for active, new, price change, back on the market, reactivated, not contingent. Does that make any sense to you at all? So there are many reasons why, you know, a bird in the hand here isn't that good a deal. You got a sale, but it's contingent upon something you can't understand, and it's going to limit the number of showings you get. Probably eliminate them altogether, even though you can tell your client that you'll make it available for show. It'll never come up based on the way people use the MLS.
So as a buyer looking at the houses that are listed on the MLS, all we see is contingent, we don't know contingent on what?
Yeah, I'm not sure when the bottom, because the MLS doesn't have a public-facing website here. So what you're seeing is whatever feeds through to a broker's site, and I'm not sure how that works because I've never used that kind of a feed. Do you know if you've looked at properties? Do you know?
I know it says contingent.
Okay.
I've never noticed.
On what? Yeah. So when you would look at that, probably you would look at that and go, oh, it's sold.
Right.
Exactly. And so that's my point exactly. So even it could be like this, And you and Dave could be like non-contingent buyers and be really interested, but your thought is, it's gone. And I would submit that the odds are, it's gone. Even though financing can fall apart, or the inspection could be bad, or whatever, it could just be something like this that it only looks sold. So again, that's a perfect example of why I, as a broker, the way our local MLS works, the MRED database, is that contingent is kind of problematic. If they ever change this field arrangement, then I would change my view of that. But for now, I think it's problematic to do that for clients. All right, again, don't worry too much right now about the property close and sell contingency. Note the basics of it, read it a little bit. We'll cover it in more detail in Real Estate 105. Amendments, I mentioned this. An amendment means a change. Addenda, additions. We don't draft them, we don't write them, they're attorney drafted. Your client can draft them. If you are sitting, negotiating with, working with your client, negotiating with the other party, whatever, and they want something written or drafted to cover something that's not in the contract, you can hand them a blank piece of paper and a pen and say, you can write this yourself. You can't do it, because that's the unauthorized practice of law, absent some advice from an attorney over the phone, that pre-drafted paragraph I mentioned before. But your clients can write whatever they want, and if it's stupid or crappy, then the attorneys can fix it after the fact. A lot of clients don't like doing that, but at least they have the legal right under pro se to do that for themselves. Back at the beginning tonight, I talked about unilateral contracts. Options are a unilateral contract. This is the thing that you're likely to see that's a unilateral contract in real estate. And even that, you're not too likely to see it. So an option contract does not have a buyer and a seller. It has an optionor and an optionee. So let's say, as a real estate developer, Steve wants to, he's looking at buying 40 acres and turning it into a new housing development. But he's not too sure about whether it's going to work or not, and he needs a lot of time to figure it out. So he has a couple of options. Right? He can go to Cecilia, who's the owner of the farm, and say, I'll buy your farm for X amount of dollars, contingent upon financing and zoning and engineering approvals and an annexation agreement and a long list of stuff that if any of that doesn't happen, in theory, he should get his earnest money back and he's free to walk. But if it all does fall into place, he's now obligated to close, even if he doesn't want to. So for a developer whose fortunes might change over some period of time, he might prefer an option. And he says to her something more like this. Rather than put up $10,000 in earnest money, I'm just picking 10 as a number, I'll give you $10,000 as an option fee that if I close, applies to the purchase price. And if I don't close, it's yours to keep. Now we have consideration. And the option is this. I have the right to buy your property. Right? He's the optionee. He's the one who holds the option. She's the optionor. She owns the property, and she grants him this option that says, you have the option to purchase my property at the following price. And the contract would be good for whatever period of time, 6 months, a year and a half, whatever the parties agreed to at the beginning. But even if Steve gets all of his approvals, he would still have no obligation to close. And Cecilia would have no right to sue him for specific performance if he did not close, because he was never a buyer, he was only an optionee. He held the right to purchase, but had no obligation. She's the one with the cat. She's the one who's got the position of now, oh, you're returning my cat? Fine, I'll pay you the $5. If he chooses to exercise the option, she's obligated to sell under the terms of the agreement. So that's the unilateral agreement. She's obligated to perform. He is not. Once he exercises his option, now you've got a sales agreement. A sales agreement that is based upon the terms in that option contract. So where options would typically get used in real estate are something exactly like I'm describing. A developer who's just not sure and who doesn't want to get tied into an actual sales contract and who would rather risk the 10 grand fee knowing that they're clean, they can walk away. Even if the deal meets all their criteria, but they have a better deal down the road, they could just say, I'll lose my 10 grand because I can make a lot more money if I do this one instead. So that's an option agreement. Also, sometimes people refer to this kind of as, it's different, but it's a similar idea as a first right of refusal. So during the period of time that Steve and Cecilia are under this option contract, if I come to Cecilia and offer her 10 times the amount of money that Steve has offered her, she can't sell me the property, because she's obligated to wait for him for that full option period or until he decides to close. And maybe he decides residential development here is a terrible idea. I don't want to do the deal. But I know that Luxon is into some other kind of development, so I'll see if he wants the deal and I'll sell him my option contract. So maybe he pays 10 grand for the option to buy the farm, and in the meantime industrial development is exploding, the land is perfect for that. He doesn't know squat about industrial development, doesn't want to do the deal, doesn't want to take title to the land, maybe can't even get financing because of his lack of experience, but maybe he sells me the right to buy the land for 20 grand or 50 grand or 100, and basically assigns me his option, which would be good for me until the time of whatever the original option expired. Brokers can even broker for a commission option contracts. Doesn't happen very often, but it can be. But to be paid a commission to sell an option contract requires a real estate license in Illinois. We'll talk about the idea of options again in chapter 17. It's not an option contract, but it's an option provision within a contract. I have the right to stay and extend my lease. I have the right to buy the building, those kinds of things. So we're really talking right now in this chapter 11 about the option contract, the right but not the obligation to buy, the obligation to sell if it comes to pass. But in chapter 17, we'll be talking about option provisions as a part of a larger contract form. Last thing, land contracts. So this is a little bit of finance and a little bit of contract. Land contracts, as they're called here, have a lot of names. Installment agreement, warranty agreement, installment agreement for deed, installment contract, contract for deed. I've even seen places where it's called real estate contract. That's confusing. But the idea of a land contract is it's basically seller financing and a sales agreement rolled into one. The seller retains legal title, so you don't have a typical closing. There's no deed at this point in time. The seller retains legal title, and the land contract agreement transfers equitable title to the buyer. Usually what's happening here in Illinois is that the parties will enter into a 5-year term agreement. Maybe the financing amount in the contract is based on a 30-year amortization, which we'll talk about more in finance what that means. So it's based on a longer term period, but the contract is only good for 5 years. Because so long as a land contract is good for 5 years or less in Illinois, the seller can take back the property in the event of a buyer default without going to court. It's the only case I know of a non-judicial foreclosure in Illinois. Very powerful position to be in as a seller. Your name never left title. Buyer's purchasing the property and making principal and interest payments under the terms of the land contract. If the buyer misses a payment 1 month, you send them a notice of default, and the property is automatically yours again. Equitable title reverts to you based on the terms of the land contract. The buyer is out. Everything the buyer paid is defaults now to be considered rent, and you can evict them since they have no legal right to be there, and you can sell the property again to somebody else. It's a very powerful tool for a seller. No standard contracts for this, so you need an attorney to draft the agreement. I literally sold a property under a land contract in Aurora many years ago, bless you, where the seller, my client, refused to hire an attorney, so we convinced the buyer to hire the attorney to draft the contract, which probably cost him about $3 grand. And when the contract came back, my seller said, "Here, look at this and tell me what you think." I said, "Well, why would you want me to do that?" "Well, I just need your opinion." I said, "Well, I can't give you a legal opinion." "Well, I'm not hiring an attorney to review this." "Well, I can't give you a legal opinion." "I don't want a legal opinion. I just want you to look at it and tell me what you think." So I told the seller, I said, "You're paying me. I think my part of the commission was $21,000. And I told the seller, I said, "I really appreciate that chunk of change, and I really appreciate your business, but I'm not risking my license for one deal. You could hire an attorney to look at it, or you're on your own." I have never, ever talked to that man since, not under any length of business at all. They did that land contract, and it almost went all the way to the full 5 years. Didn't quite close. I got monthly commission checks at the end, but when that deal fell apart, he relisted with somebody else. I'm not going to work for somebody who won't hire an attorney to represent their interests and expects me to do it. I can't. It's risking my license. It's the unauthorized practice of law. The challenge with commissions here under a land contract is there's no cash up front. For a buyer, it's a pretty good deal. They can buy the property with no money down because the seller already owns it, probably free and clear of debt for reasons I'll explain in financing chapters. So the seller owns the thing free of debt. The buyer pays whatever price the seller's asking. No credit check, no appraisal necessary on the property. You just purchase the property. You just agree to this land contract and you start making payments. And if, let's just say you purchase the property for $100,000, and at the end of the year it's worth 105, right? So this is at the very beginning, so we'll call this year 0. The end of 1 year, it's worth 105. The end of year 2, it's worth 110. The end of year 3, it's worth 115. The end of year 4, it's worth 120. And somewhere in year 5, this place becomes worth at least 125 grand. Okay? Somewhere in there. You've also paid this down, right? Because you've made principal and interest payments. So at the end of year 5, this place is worth maybe 90, or you owe maybe 95K. The buyer can now take that property, in which they have equitable title, and they can go to a commercial lender, and they don't have to get new financing. It's a refinance because they've already bought it. So they can refinance this property, and look what they have, 25% equity or thereabouts. Plenty of money for the lender to be happy, and they've got 5 years evidence of solid payments, which if they had no credit or crap credit here, right, that's all worked itself out. Even if initially, bless you, the seller sells the property for 100, even though initially it was only worth 95, they've still made up for that, and they still have room in here at the end. So even if you overpay a little as a buyer, this can be a cool way to get into a deal. And for the seller, you're not only selling the property maybe at a slightly above market value rate, but you're collecting market interest rate, which in today's world, getting 4 or 5% on this kind of money is huge when you can't get anything in a savings account. Again, for the buyer, the challenge is if you default, you're gone like that, you're out. The challenge for the seller is if you have any debt against the property, you probably can't do this. Also, who's paying the property taxes along the way? What if the party responsible doesn't do that? How's that going to get worked out? It's all got to be addressed in the land contract. So the attorney fees up front are higher. The commission challenge part, since there's no cash down at the beginning, there's no money to pay you a fee. I've done 2 land contract deals that have been problematic. I had a former student who did another one. She also had a problem. So what I got was for 5 years, I got partial commission payments along the way. Our office would get 7% out of every payment that was made over 5 years. And seriously, at 4 years and 11 months, the buyer went to the seller and said, we don't want to close. We'd rather lose everything we've put in, or if you're kind enough that we're a nonprofit buyer, we'd like the money back, and we want to go buy something else. The seller gave them back every stinking dollar they paid and let them out of the deal, which meant the remaining part of the commission for us, which was still like another $30-some thousand for the office, half of which would have been mine, didn't come to us at all. But the seller did that because the land, he originally sold it for 600 grand. He got an appraisal at like $1.1 million 5 years later. So he was perfectly happy to take that kind of appreciation, which now about 7 years later is still sitting there vacant and unsold. I don't know what it's selling for now, but I bet it's a lot less than that. Not less than the 600, but a lot less than $1.2 million.
So then, because the seller backed out, could you guys enforce him to pay the commission that was due?
No, that's not how we had the commission agreement written. The commission agreement was written that we simply got paid 7% of everything he collected, with the anticipation we would get our final commission 5 years into the future. Had we written a different commission arrangement, then maybe, but we didn't have that right in the agreement.
Gotcha.
So just keep that in mind. If you do a land contract, you probably ain't getting paid right away. And even if you do, it's going to be far in the future. And of course, your broker's got to agree to all that. I also put these terms up here. Sometimes the seller is referred to as the vendor and the buyer is a vendee under a land contract. I won't test you on those terms. I don't know if you see that at the state exam,
Is the
Steve.
deed conveyed until it's completely sold?
There's no deed conveyed whatsoever until the buyer goes and gets their own financing and then takes the seller out through that mechanism.
So as far as the taxing body, you're still responsible?
The seller is still gonna be on title, correct. Exactly. So, test question purposes, you need to understand enough about this to recognize there is no closing per se under a land contract sale until the buyer basically takes the seller out of the deal. You don't have to have this 5-year term, but so long as the deal is 5-year term or shorter and the buyer has not paid in 20% or more in Illinois, then the seller retains that right to say, you default, you're out, it's all mine again. If the buyer puts down or pays during the term 20% or more, or if the term is for longer than 5 years, then the seller doesn't have that right. Okay? Questions about land contract? It's not typical, again, particularly for you as brokers, you could happily go your whole career and never be involved in one. But from a real estate standpoint, for investors, for whatever, it's good to know that they're out there and that they're a possibility. I think this is the last slide. I do this sometimes and it turns out there's 20 more. Oh, there we go, got lucky tonight. All right, so if you haven't grabbed one already, grab a quiz. When we get together next week, we'll do chapters 12 and 13 on Tuesday night. Self-test on this and see what you have in terms of knowledge and ability for now. If you have any other questions, I'll be happy to hang out with you for a while. Otherwise,